Good morning, everyone, and welcome back to our weekly webinar series. We're continuing the subject that we had taken up last week, and it's a very, very important topic. We are talking about the guidance on common issues observed during the monitoring inspections of IPs. Over to Anil.
Thank you, Ankit. Uh, Welcome to 132nd episode of AAA Weekly Webinar Series. In the last webinar, which is 131st webinar, we started with the deliberations on the guidance note issued by IIIPI, the Institute of Chartered Accountants, IPA, and they have done a nice job of collating all kinds of errors and mistakes and non-compliances done by the insolvency professionals, either during their resolution process or during the liquidation process. So we discussed the objective, we discussed the sources, and also we tried to relate it with the any supporting order of IIIPI or any judgment from NCLT or NCLAT or even Supreme Court or High Court. So therefore, the complete guidance is on how to safeguard yourself by the insolvency professionals. It is very important that we are a AAA insolvency, we have association with 75 insolvency professionals, some as designated partners and some associate partners. We are advising our all associates insolvency professionals that they have to comply with all regulations and what is compliance, what is not a compliance as per IBPI, as per IPA, and as per various orders of NCLT, NCLAT, or Supreme Court, or even High Courts. That is what is being discussed today. Part 1 was discussed on last Saturday in our 131st episode, and now we are today discussing part 2, which is exactly continuation of the discussions and elaborating, supported by the IBPI judgments and other judgments on various issues which are considered as common mistakes made by the insolvency professional in the processes. So coming to our own subject, so we discussed many issues like the various issues. So today we will start from the uh, one, the heading. Heading is appointment of resolution professionals. So the IIIPI, the Indian Institute of Insolvency Professionals of ICAI, this is the full name. IIIPI has divided their study, their note into different parts, and that part that we are discussing, we are starting from today, is the where the heading, the key subject is appointment of resolution professional in corporate insolvency resolution processes. Now, in this, the first common mistake that has been found by IPA is the delay in appointment of IRP or RP. Now, the delay in appointing the IRP or RP leads to delay in initiating or continuing the CIRP process. Now, any delay in appointing IRP, that is only for the adjudicating authority to see, and the insolvency professional has to act when the order is passed, appointing him or her as IRP. So therefore, as far as the appointment, any delay in the appointment of IRP is concerned, that is not in the hands of insolvency professionals, but what exactly the IP wanted to say, that the delay in appointment of RP. Delay in appointment of RP, because see, there are cases that the IPA has seen that the IRP is not even presenting a resolution appointing RP, because the IRP has to finally be converted into, the RP has to be appointed. Interim IRP has to be converted or somebody else has to be appointed as RP. That is a must. And case in case the COC is not able to change the RP because of the lack of voting, which requires 66%, then in that case, the IRP will start functioning as RP after 40 days of his appointment as IRP. However, if the IRP is not even trying to present a resolution for appointing him as RP, that is a non-compliance. IRP has to present a resolution before the committee of creditors for appointment of RP. In case any other person is suggested by the COC, then other person as well as the RP himself also can be said that I am also a candidate for appointment of RP. But the most important is that the IRP must make efforts to appoint RP, maybe to himself or maybe to somebody else. Now, in some cases, the RP is continuing beyond the IRP period without even formal approval of COC, leading to non-compliance. This also I could not understand. I only understand one thing, that in case there is no RP appointed by the COC, IRP duty is that IRP will say that this is the resolution that you have to approve. In case the IRP, is not made as RP and any other person is also not made as RP, then the IRP is continuing as deemed RP. So I repeat, in case IRP is not appointed as RP and any other person is also not appointed as RP, then IRP is continuing as RP, as deemed RP. So primary responsibility of the IRP is to present a resolution for approving appointment of RP. And in case he is not doing this, then it is a non-compliance. Then appointing an ineligible RP. Now the RP is recommended by committee of creditors, and the voting is done by committee of creditors. Whether the person is eligible or not, that is also the duty of COC. If any person who actually is not eligible because of any suspension order or because of the unavailability of AFA, I think that is the duty of the committee of creditors. But what I feel, that in case any person who is getting appointed as IRP or RP having no valid AFA, that is also tantamount to a disciplinary action, because he doesn't have the AFA and he's getting himself appointed as RP or IRP. That is something that we should avoid. Then the most important part is that the overlapping roles of the RP with other stakeholders. RP is appointed as RP for the CD corporate debtor. No, he cannot provide consultation on a commercial terms to any of the stakeholder. He cannot provide consultation. He cannot become auditor. He cannot become any other. He cannot provide any other professional services. Now, who are the stakeholders? Committee of creditors, like the overlapping roles of the RP. RP cannot take up any other assignment from the committee of creditors for this particular case. He cannot prepare a resolution plan which is to be submitted in this case. He cannot become a consultant and charge some fee from the committee of creditors as a consultant. He cannot become a consultant to resolution applicant. He cannot become a consultant to promoters. He cannot have any role with the stakeholders. That is where the error actually is very, very serious error. And the IIPI will take a very serious action against a person who is taking different roles from the same stakeholder. Then I think the failure to file CIRP Form 7 every 30 days to record any delay in any of the process, including the appointment of RP. If it is delayed every 30 days, a Form 7 has to be submitted by the RP. That is common in all the headings. Now, in this particular case, I would also like to have another judgment, which is a judgment from NCLAT Principal Bench, New Delhi, in the case of Sri Gopal Chaudhary, RP of Shri Ram Urban Infrastructure Limited versus Sarai Equipment Finance Limited. And this judgment is dated 10th January 23. And it is in this particular case, the CIRP started on 6th November 2019. And the first meeting committee of the first COC meeting was held on 19th April 2021. 19th April 2021 was the first COC meeting after a delay of 1.5 years. And in this particular case, despite various multiple requests, the primary issue was whether the adjudicating authority had the jurisdiction to remove the RP when the RP failed to convene the COC meeting for the purpose of his removal as requested by the COC. Now, NCLAT held that the adjudicating authority's decision stating that the authority had the inherent jurisdiction to remove the RP when RP did not convene the COC meeting, the appellate tribunal dismissed the appeal and directed the IBBI to conduct an inquiry into the conduct of the RP. The decision emphasized that the one who appoints, that is the adjudicating authority, also has the power to remove, particularly when the RP fails to perform his duties effectively. When the RP fails to perform his duties effectively. Now, very important one, we have to take a lesson that the RP has to convene a meeting where the RP makes an effort to appoint, IRP makes an effort to appoint RP. That is very important in this chapter. And secondly is the any role which is clashing with the role of the RP and in fact diluting his independence. That kind of role cannot be accepted from any stakeholder. So that is also a kind of takeaway from this chapter. Then is the information memorandum. I have seen that most of us are making errors in information memorandum regarding what should be the total contents. Even if the information is available, the contents are not updated. Now, the IM is not prepared within the stipulated timelines, which is 92 days, I think, these days. Reasons not recorded in the minutes. And the delay in the preparation of IM, in fact, violates the statutory timeline and hampers its efficiency. This is therefore, this is something which the IBBI will take very, very serious cognizance. Now, the second, again, whatever is recommended by IPA, the delay in preparation of IM, that is also beyond the timeline. And one is the IM not prepared, and the second is it is not even, there is a delay. Again, same reason that if there is a delay, reasons has to be recorded. If the reasons are not recorded, this is also not pardonable. Then the IM is not shared with the COC. If it is shared, it is shared without confidentiality undertaking from the recipient. One, confidential undertaking, that is must. Secondly, sharing with the COC is a must. And then, in case there are judgments that the COC members were given IM, but they actually had not submitted their confidentiality. So therefore, the entire confidentiality, that's a process is diluted, so not pardonable. In some of the cases, I believe there was some copyright on the IM. Maybe that some company might have developed a format for the IM and then they tried to develop a copyright on the IM. So finally, it was held that there is no copyright which can actually belong to someone. The copyright of the IM is either with the RP or with the CD. There is no third party who can have the copyright on the IM. May it be format only, may it be content, but the copyright on the IM is only ownership of the IM is only either with the RP or with the corporate debtor. So that's very clear. Now, the other important mistake which actually happens in many cases, that is the updated IM, revisions of IM, because the IM is a dynamic document, information keeps coming, and information gets into IM whenever it comes. Claims keeps coming, IM needs to be revised. There are contingent liabilities which keeps coming. There are information which comes. There are some litigation which actually fructify. All this has to be mentioned in the IM so that the person who is coming as a resolution applicant should have full information about the corporate debtor so that the value maximization is assured for the creditors. Now, if the revisions are made by the RP, if the alterations are made by the RP, if addendums are made by the RP and additional information is given in the IM by the RP, then all these versions has to be shared with the stakeholders, with the COC members. It is not required that every time you share IM, you should take a confidentiality undertaking, but the very first undertaking that we receive, we normally ask them to also write that the confidentiality would be maintained on any kind of updated IM. So therefore, this is very important that, see, since the time the regulations have changed, that the RP can accept the claims even up to the last meeting when the resolution plan is put to vote a week before. That up to that, the RP can accept claims. That means the information memorandum or as a part of the addendum to information memorandum, I think would be many. It will not be restricted to two or three. It can be many, where the information keeps coming. So what I think that every month after the first version of the IM is released, after that every month IM should be released so that the updated information is available with the stakeholders, with the and with the I mean to say committee of creditors and with the resolution applicant. Again, in case of delay of IM, we actually have to say form CIRP form 7 has to be filled, and that is again a kind of regular error that in case of delay of various processes, then CIRP 7 is not being submitted. Now, in this case, on 3rd February 2023, IBBI passed an order. IBBI passed an order, and in that particular case, the issue was that the information memorandum was not shared with the COC within the specified timeline. So the RP in fact started that one appeal was pending. Therefore, he did not uh, share. So in this particular case, the RP represented before in IBBI that the IM was prepared on time. It was placed before COC meeting. And then he said that he informed the COC that the IM would be shared upon receipt of confidentiality undertaking from the COC members. Then he also said that he delayed sharing the IM because of the pendency of NCLAT hearing, but no request for IM or confidentiality undertaking was even received from the COC members. He denied misleading the COC. The decision of the decision of the disciplinary committee of IBBI was that the insolvency professional service provider complied with the confidentiality requirement. However, the IBBI found that his statement before the COC suggesting that the IM could not be shared due to pendency of NCLAT appeal misled the COC members. Since there was no stay from NCLAT, the DC held that the IP have shared the IM with the COC members. Therefore, the disciplinary committee concluded that Mr. RP violated the regulations and clauses 5 and 13 of the Code of Conduct. Then another order dated 26th of May 2023 from IBBI, it also has this dispute whether in this case the DC found that the IP's claim that the information regarding the FAR and non-FAR was actually presented. So the dispute in this case was that the IM had different information about the total square meter of square feet of FAR and non-FAR area. So there was a difference in the two figures. One figure was in the IM and the other figure was in the resolution plan. So therefore, the disciplinary action started that both these figures must match, which actually hampers the value realization. So this is also one important judgment. So any question that we can take up, Ankit, as of now?
There are four questions that we can take up. So one is that if another IP is appointed as RP in the first meeting, but the IA for RP appointment is heard and ordered in 2.5 months, then what is the responsibility of the existing IRP? So the law is clear, the existing IRP continues to function as the RP. He is supposed to do everything that is possible. It all depends on the COC support. We have seen that the IRP has been decided, the COC has decided the IRP will be changed. They appointed an RP, but the IRP continues to perform all the mandatory duties, including publishing Form G, etc., etc. We have seen that happening. But of course, if COC does not say yes or give financial approval to the decisions of the IRP, that might be a limiting factor for him to perform his duties. But otherwise, legally, he can do everything.
Legally, after 40 days of his appointment as IRP, he will start functioning as deemed RP and will do all the duties of RP.
Exactly. Then next question is whether IM is to be prepared by the RP, wherein the COC decides not to publish Form G and recommends for liquidation of the CD. IM is still supposed to be prepared. I don't think it's linked to Form G.
So
We can
there is a
understand.
conflicting views about this, Ankit. One, that in case we read the regulations and we read the section, IM is basically required for and basically used for preparation of resolution plan. But it also has all the information about the corporate data.
Hmm.
So in case the IM is not prepared, then what is the document that the COC will rely while deciding that no expression of interest should be released in this case and the company may be liquidated? What
Hmm.
information the COC will realize? So whatever information that the IP gets, that can be documented only in IM. That IM can be presented before the COC. However, in case the COC decides to liquidate the company before even 92nd day, then there is no IM required. But in case the 92 days have already passed or it is approaching, then IM has to be prepared and submitted. But in cases where the COC decides to either there is any proposal under section 12A or there is any kind of uh, any kind of decision of the COC to liquidate the company, then if it is before 92nd day, then no IM is required. But once the 92 days are passed, IM is required to be submitted. Even if later on the COC decides, or even if before that the COC taken a decision to liquidate the company, but the resolution is not yet approved for liquidating the company, 92nd day the IM must be shared with the COC members.
Then we have a question that resolution to confirm the IRP as RP was not passed with the requisite percentage. COC has not proposed appointed new RP. Should IRP inform the situation to NCLT or continue to act as RP till approval of resolution plan liquidation order by AA? So he's supposed to continue to act as an RP. He is not required to go to NCLT and report this in any way. He's supposed to tell the COC that as per the regulations, I am the acting RP and he should perform all his functions accordingly.
Even if the resolution for appointing another person is approved by COC, even if an application has been submitted to adjudicating authority for replacement of IRP with another RP, the IRP will continue to function. and IRP will be eligible to get fee up to the date of actual order where the another IRP is appointed. Yes, sir.
Then which is the date of appointment of RP? Is it the date of approval of resolution by COC or the date of order of AA? Officially, the appointment
Date of
date or confirmation date is the AA date.
date of order.
Date
Date
of
of
order.
order.
Then whether AA is permitting IRP to hold COC meetings and appoint another IP as IRP by exercising special powers. How can AA exceed IBC law itself? When AAA is not permitting IRP to hold. So the question is that if COC meetings are not being allowed by the adjudicating authority or the appellate authority in any case, then what are the ways forward? So the IRP continues to operate as
IRP continue.
RP.
Only the COC has the power to replace the RP. Otherwise, IRP has already been appointed with all the powers. So IRP will continue. If it is after 40 days, then he will function as RP also.
If AFA has been expired in last month and IP has not applied for its renewal till date due to any reason, what will be the implication on the cases of IP? So IP cannot take any new cases. So during this period, in case, let's say a case comes in where he might have been appointed as the IP and the AA orders him to become the IP in that case, or the RP in that case, or the IRP in that case, then that's a problem because that's a new appointment and it has come to the IP without an AFA. So when the IP goes back to NCLT says that this appointment has been done, sir, but AFA was not there, then the NCLT will be forced to pass an order changing the appointment. That's what will happen.
Yes, that's correct.
So we can continue with the other queries. Then maybe we can have some uh, uh, some questions on the in speaking mode also.
Okay, so I think there is one Amarjeet Singh. Actually, he's raised hands. Should we take it up now or later?
We can take it up now. We can take up then Anilji's question can also be taken up. He can also raise his hand.
Yes, yes. Already there are two hands are raised.
May I speak, sir?
Yes, Ashwini.
Yeah. So many time it is almost at all the time when there is a change in RP in the first COC meeting or second COC meeting, and then procedure to be followed for IEA filing and approval by IEA by NCLT. Now this is all governed by the regulation, but the practical issue do arises because COC then feels that let the new thing be done by the new RP, and there are delays then in CRP. So means IBBI should consider COC
There is a, you see, like
wisdom is there.
sorry, Ashwini, the IBBI, I have understood the question. You are saying that once the resolution for replacement of RP is passed, now the IRP is continuing because NCLT is taking 2 months time or 3 months time in passing that order. In the meantime, 40 days have already lapsed and the IRP has to function as RP as per the sections. Now, if the timelines are being followed, according to the timeline, if the IRP or deemed RP has presented all those decision-making process before the committee of creditors and committee of creditors reject that by voting, I think that is the duty that the insolvency professional has to do, irrespective of the fact whether the COC passed that resolution or failed that resolution. In case COC passes the resolution, then the process will start and the person who actually is being removed by the COC will have to function till that time. In case the like the IRP is not appointed, RP is not appointed. So in case the COC does not pass the vote, does not pass the resolution, then IRP has done its duty and the new RP will come and again do that.
I got that, but now there is a need for IBBI to consider this aspect and make some suitable amendment in regulation. Because ultimately, every time we are saying commercial wisdom of the COC will prevail.
But I have seen many times if the resolutions proposed by the outgoing IRP or outgoing RP are reasonable, then the COC is accepting those. With the COC is not rejecting. For example, appointment of valuers because there is a timeline. For example, appointment of forensic auditor. The COC is continuing. The COC is passing those resolutions. My experience. But the only thing is that the COC should see that these appointments are valid and these appointments are being done by following a process. The fee quoted by various people are competitive, then the COC will appoint. In case the COC see that these appointments are not considered rational, then the COC can otherwise also reject, even if the COC has appointed an RP. Yes, I think Amarjit ji, please. Amarjit ji, would you ask your question? Okay, then we have a company secretary, A.K. Mittal, please. So I think we can go to the next subject, and those next subjects are regarding the expression of interest, regarding the RFRP. There are observations of IPA on these two subjects. One is the delay in placing before the COC an agenda for issuance of expression of interest. In many cases, the IPA has seen that the RP or the IRP is not even placing the agenda before the COC for issuance of expression of interest. The observations are that this kind of delay impacts on the entire CIRP timeline, and it also reduces the effectiveness. So therefore, all the IPs are advised to go for expression of interest, place it before the COC. COC may take time to accept it or reject it. That is a completely separate issue. And then, like in some cases, even the substantial time has been passed. Now, the minimum timeline of 15 days is supposed to be given in the EOI. I have seen in some cases the RP is not even giving minimum 15 days time. That is not acceptable. That is not pardonable. Unless there are reasons recorded, unless it is also specifically approved by the Committee of Creditors. So this is what is the IPA feels, that it is something which is not pardonable, that we are not even giving 15 days time to public to submit expression of interest with so many documents. Shortening timeline is the objective, not at the cost of injustice to some who are not able to do this within 15 days. So therefore, 15 days time is sacrosanct. Then we also see that some of the RPs are even admitting those people who are not eligible as per the eligibility criteria. Something that has been written in this IPA, that without approval of the COC. I am saying once the eligibility criteria is decided by the COC, then in that particular process, everyone has to go through that eligibility criteria. It is not possible that we have made a requirement as eligibility requirement is 1 crore of net worth, and the two people who have submitted their expression of interest has 1 crore of net worth. But however, there are other two, they do not have 1 crore of net worth. Then the COC does not have power to include these two also in the process. That is challengeable because the injustice to public at large. Otherwise, it will be a kind of total injustice to those people who wanted to participate into the expression of interest, but they were not having 1 crore of net worth. Therefore, they abstained. But without even knowing that there will be two people who submitted their expression of interest and they will be admitted. So therefore, it is injustice. So even COC approval is required only for the next process of issuance of EOI, not in the same process. Even in some cases, the expression of interest is accepted after the after the deadline mentioned in the Form G. So in this case, this is also a kind of not pardonable kind of mistake. Again, the deadline, timelines are not mentioned correctly in the Form G. That is also a common mistake. Then accepting non-refundable deposits is not acceptable, because see, the IBBI issued a circular in 2021 that this refundable, all the deposits should be refundable and the deposit should not be non-refundable. Then, of course, in case there is any delay in the process, which is the issue of EY or RFRP, then Form 7 of CIRP has to be filled. That is also a requirement. So in this case, we could locate one judgment from NCLT Division Bench Chennai, which is State Bank of India versus Coastal Energen Private Limited. This judgment is as latest as 30th August 24. So in this case, it was held. The issue was whether an EOI received after time specified in Form G can be accepted and considered by the COC in the CIRP process, especially when the IBC and the regulations emphasize strict adherence to timelines. In this case, NCLT very clearly held that the NCLT ruled that the acceptance of an EOI submitted after the deadline specified in Form G was irregular. It was irregular and should have been rejected as per Regulation 36A of the CIRP regulations. The court further emphasized that the strict timelines are an essential part or feature of the CIRP process, and any deviation from the deadlines specified in Form G undermines the sanctity of the process. However, after saying all this, in this case, considering that the COC exercised its commercial wisdom and no objection were received at the time of evaluation, the court upheld the approval of resolution plan. So it was already approved. The resolution plan was already approved, and since the resolution plan was approved, one person said that this particular SRA who has finally submitted the resolution plan has not submitted the expression of interest within the timeline mentioned. So the court said that it is a requirement, but some special cases we are considering it. Now is the various observations on the resolution plan. Now the resolution plan is primary responsibility of the resolution applicant to prepare that resolution plan. Secondly, the resolution plan has to be presented before the committee of creditors by the RP. After considering compliances, like whether the resolution plan is legally compliant. Number two, whether the resolution plan is compliant to the eligibility criteria. Then also, it is the duty of the RP to see whether all the terms and conditions of the resolution plan are compliant with the issue of RFRP. So these are the three things, and then only the resolution plan can be voted upon. Now, I also see that there are some other errors in the resolution plan, and one such error is the distribution amount of the approved resolution plan differs from the last updated creditor list. Therefore, I said that the IM, whenever we revise, we must submit to creditors as well as to IBPI. I think there is a form for submission of IM. Secondly, the discrepancy is not pardonable, because it is the duty of the RP to see whether the resolution plan submitted or the resolution applicant has got the possession of information memorandum which is updated. Now, another important part is the clarity on handling uninvoked bank guarantees in a resolution plan. Now, one thing that we have seen in our last week webinar, that if there are bank guarantees outstanding, we should admit that claim as contingent claim. We should admit that claim as contingent claim. That is something which is required. Information memorandum must have the details of all uninvoked bank guarantees, and uninvoked bank guarantees has to be, and this kind of contingent liability has to be clearly mentioned in the plan to avoid future disputes. This treatment is very important because the claim has been filed by the uh, banker, that they have issued the letter of credit. We have also seen that the margin money is not the asset of the corporate debtor. So therefore, the unless the clarity is provided in the resolution plan would not be approved. Now, another uh, observation of IPA is the ineligible resolution applicants under Section 29A. They are submitting the resolution plans, and this should not happen. Either there could be an error in looking into the documents, but this is not something which is really pardonable, that the uh, person who is submitting the resolution plan is not even compliant to Section 29A. Then in some cases, we've seen that the successful resolution applicant is also a kind of creditor of the company. What I'm saying is, the uh, the successful resolution applicant is also a claimant in the CD, and he cannot say in the resolution plan that first I will distribute to everyone, and whatever would be left I will adjust it with my loan. That is also not something which is acceptable. If it has to be done, it has to be done very, very clearly by disclosing all the facts. Then it is also suggested that the resolution plan must have a projections, detailed projections and implementation timeline of the resolution plan. So therefore, inadequate details on the financial projections and timeline affects the viability of the resolution plan and its acceptance by the COC. Again, failure to mention the how dissenting creditors will be treated in the plan. Now, as per the regulations, or as per Section 30, subsection 2, the dissenting creditor should get as per the resolution plan, the or the liquidation value due to the financial creditor, financial creditor. Now, in case the liquidation value due to dissenting financial creditor as per Section 53 is not significant, then he is not entitled to any distribution. But still, in case any distribution is made in the resolution plan, that is also important. That is what is to be given to the dissenting creditors. But in case this is not provided in the resolution plan, this is also considered as the plan is not compliant, and RP should have seen this, that the resolution plan is not compliant. Even in the case of very old case of Supreme Court of India, in the case of Bank of Baroda versus IIIPI versus MBL Infrastructure Limited, in fact, it was held by the Honorable Supreme Court. So it was held that the RA, whose personal guarantees were invoked and remained unpaid, was disqualified under Section 29A. So there can be any guarantor to the corporate debtor. So was it disconnected for some time, Ankit? You're mute.
A minute that we lost you, so you can continue.
So this is one case of Supreme Court in the case of MBL infrastructure, where it was actually held that the any promoter or any person who had given a personal guarantee and his personal guarantee was invoked, so he was not entitled to under Section 29A. Another judgment from Hyderabad bench in the case of Ravi Shankar Devarka Konda versus IDBI Bank Limited, and this judgment is 29th of March 2023. In this case, I would simply say that the margin money deposited in the shape of FDRs by the corporate debtor to secure a bank guarantee to be considered, that can be considered as asset of the corporate debtor or not. So this judgment has come from NCLT Hyderabad, and it is the final decision is number one. The tribunal held that the margin money deposited against bank guarantee does not constitute an asset of the corporate debtor. It is held in the trust for the beneficiary of the bank guarantee. Second, the NCLT emphasized that the bank guarantee are independent contracts between the bank and the beneficiary unaffected by the underlying insolvency. Third, therefore the FDR cannot be released unless the bank guarantee are discharged or expire, dismissing the application filed by the IRP. So there is another case that I would like to say. This is the Phoenix ARC Private Limited versus Anush Finleys and Construction Private Limited from NCLT principal bench, means Delhi bench, and the facts of this case was slightly longer. Then again, I am saying whether the margin money securing on uninvoked bank guarantees can be treated as the asset of the corporate debtor during the CIRP, and if possible, and if a provision can be made soothsayer. Now, in this case, the decision of the NCLT is that no provision can be made with respect to an uninvoked bank guarantee during CIRP. The margin money deposit serve as a trust for the beneficiary of the bank and does not form part of the corporate debtor's assets. NCLT emphasized that until the bank guarantee is invoked or expired, the margin money cannot be treated as an asset of the corporate debtor or used for any other purposes. So in case there is any bank guarantee, performance bank guarantee have either expired or it has been invoked, then that margin will be used by the issuer of bank guarantee, may be performance bank guarantee. But in this case, the application was dismissed by RP. The application by the RP was dismissed, upholding the bank's right to retain the margin money, ensuring that it remains available to honor the bank guarantee if involved. So this is also a good judgment. Now, Ankit, we are left with 10 minutes, and I can quickly, for 5 minutes, I can quickly take up one, that the delegation of authority to team members for chairing the COC meetings without obtaining COC approval, taking COC approval is non-compliance. The COC meeting has to be attended by the RP or the liquidator, SEC meeting by liquidator. The delegation of authority to have the meetings, that is not even provided in the laws. That will be considered as a non-compliance. Then appointment of professionals for claim verification or compliance without written records of the communication between RP and the professional. Now, in this case, outsourcing of verification process, verification of the records, that process also cannot be outsourced. That is considered to be a violation of the regulations. Failure to disclose relationship while the delegation of authority is sought under Section 828 So the relationship of the person who is getting the powers, that also has to be disclosed by the RP. Engagement of professional for assistance where the IP adopts the professional findings without documented independent view. So for appointment of professionals also, a process has to be conducted. Quotations has to be invited. Then the COC will take a decision which one to appoint, and the RP will have to work with that professional. That is what is our finding. In case the professionals are not being engaged by the RP or the liquidator, then of course on the denial, then the company can pitch in to keep the company as a going concern. So the delegation, if IP delegating responsibilities for filing applications without clear delegation, IP delegating responsibilities for filing application without clear delegation, that is also a kind of blanket permission given to a law firm, like you please do all the kind of bad work, so all litigation prepare and submit. But that also, this kind of delegation is also required to have an approval from the committee of creditors. This is a serious issue. Now we reach out to pre-CIRP cost and post-CIRP cost, and the relevant law in this case remarks payment of CIRP dues during CIRP period. So the discrepancies in the between. So what I'm trying to say is sometimes after the resolution plan is approved, the pre-CIRP expenses increased because of some additional voucher keeps coming, additional voucher for expenses. So therefore, logically, this CIRP without hearing approvals is something which is not really good, and it should be avoided. Discrepancy between this CIRP cost and minutes of the COC meeting, that also needs to be checked by all. The failure to seek COC approval for interim funding or CIRP regulation, that is also declined. Pre-CIRP professional cost forming part of the CIRP expense without approval, that is also getting rejected because the pre-CIRP professional cost, like discussing with the lawyers, and finally in case that is called pre-CIRP. Overly high operational land, CIRP, and that is a venue, the expenditures on exhibition. So that's, I think it is the same. So it also is presently a property of no use. Delayed the submission of cost under section 12A for CIRP withdrawal. That is also very important that the CIRP cost has to be informed, and then only the resolution, then only it can be said that the CIRP cost has actually been informed. Delay in submission of cost and CIRP cost not ratified by the COC or miscalculation. This is also one of the observations that the CIRP cost, in fact, was not even ratified. Lack of cost details for the CD operational cost. These are all operational issues, so that actually can be handled. So, Ankit, now we are reaching to appointment of valuers, and we are not left with any time. So in case we can see the valuer of appointment, in case if you have this note that we have prepared, or you want to speak about the appointment of valuers, I can share this note with on the screen. Would you like to see what actually is the engagement, because you otherwise do a lot of work on appointment, and that is something that I am talking about. If you can see this, so this is where we have prepared some note.
Non-registered valuers were appointed initially. I think that's taken care of now. Then engagement letters issued in the name of firms or
entity. Yeah.
So there again, RVEs, they can be appointed. RVs cannot be appointed in some other firm's name. They should ideally be appointed in their individual names. So that's also understood. Then we have common engagement letters issued with lump sum fees, creating potential conflicts of interest. So, lump sum fees, wherever, like let's say three valuers pitch in and say that, okay, we are going to work together. This is our common fee. They have to give a distribution in those circumstances. Sometimes we find quotations coming in from three independent valuers who are giving a combined quote and saying that we will take care of all the three asset classes together. And there the lump sum fee cannot be there. It has to be broken up so that the RP knows that who is required to be paid what fee once the assignment is over. Delay in appointing registered valuers. One of the practical issues when we see appointing valuers is that wherever the COC approval is not in place with respect to the valuer fee, normally we feel that the COC might be inclined to uh, you know uh, to seek a discount on the fee, that is a fee proposal that has been received. Sometimes the fee cannot be rather understood that what will be the fee because of data not available, or not, it is not understood by the IRP within the 47th day that what are the assets that are required to be valued. So in those circumstances, we see that appointment letters are issued with a clause that, okay, the fee will be decided later or the fee will be determined later. It can also be issued with the caveat that the COC is yet to approve the IP fee. As a good practice in our office, we try to get the valuation quotes by the first COC, and we place this resolution for approval of the fee for registered valuers in the first meeting itself, so that we can complete the appointment by 47th day. That normally helps in expediting this process. So one of the agenda items of first COC meeting is to also approve the valuer fee. Non-appointment of valuers for all asset classes leading to incomplete valuation. So yeah, there can be a possibility that there are certain asset classes where the RP is not able to find enough information to get a valuation done, and that leads to a situation where he does not have a valuation opinion for certain asset classes. Example, let's say you have an SFA, you have a balance sheet which comes to you as an RP, let's say by second or third month. By that time, you understand, oh, there are some securities or financial assets in the company, and you have not appointed a valuer, believing that there is no SFA asset. So that can be a concern. So good practice is appoint the values for all three asset classes so that any work that comes out can be taken care of there. Lack of records showing the reasonableness of fees or conflict of interest disclosure. So yes, whenever we kind of seek quotations, we normally follow a system that either we are sending the quotations to RVEs who are who are having who are having a system to kind of um, get all asset classes done, or we kind of look at valuers who are closer to the place where the asset is located. So some logical idea should normally be in place to seek quotations rather than arbitrary idea that, okay, we will send RFQs to 5 or 10 people, and not to a specific filter or not through a specific list that is filtered through a genuine process. I think that's a fair idea, so that one kind of generates that competition in the market for value fee.
Although we have still unfinished tasks, but I think the questions are more important. So we should actually try to see the questions in case we have questions.
I
But
think Anilji wanted to ask a question. Maybe we can ask him to speak and share his question.
Sir, I have two, three questions. First is regarding the valuer. Can you hear me?
Yes, yes.
When there are assets in the balance sheet, but physically they are not there, should we appoint valuer for that? Because we have appointed with the consent of the SEC members. Now they are raising objection.
Now, if the valuer is appointed with the SEC and the what you are saying that the valuer has been appointed, but what happened later?
Sir, there are physically assets are not there, but there are assets in the balance sheet. Physical assets are there.
So
An SEC meeting was called, and they had in principle agreed that all three classes of assets valuer should be appointed.
now even the law also says that the valuer should be appointed.
Yes, sir.
Once the valuer is appointed, then the what are the duties of the insolvency professional to provide all the details of the assets to the valuer.
Yes,
and
sir.
if the details are not available with the RP, then the appointed valuer will be informed that the details are not available. Then the valuer actually can also go to that physical place where the assets are supposed to be there as per the records of the banks. And in case the valuer does not find their assets, then the valuer will also give a report that he could not complete the valuation process because he could not find the assets there. So with this, we can close the valuation process, and then we can negotiate the fees with him. Since he could not do the valuation because of any reason, the only nominal fee would be given and not the entire fee.
Sir,
That is
all these
done
things
in
have
many
been
cases.
done. Sir, all these things have been done with the consent of SEC. And still now they are objecting for the expenses. That the why did you appoint valuer for all these process has been followed.
No, I said that in case the valuation could not be done, then the
Yeah.
valuers would not be given the full amount agreed because the valuation report has not been given by them. Then only nominal fee would be given, not the entire fee settled. That's what I'm saying.
So
And
we
in
have to
case,
start the renegotiation of the fee. Already we have appointed, we have
yes.
given the appointment
Because
letter.
if the valuation has not been done, then the full amount is not payable for any professional assignment. If the work could not be completed because of the lack of records, then also the auditor cannot get the full fee. He will only get the fee which is nominal fee for the efforts made so far.
Okay. And the second question is, sir, that the liquidation expenses, are they need to be ratified, pre-ratified by the SEC, or they are to be appraised by the
No,
liquidator?
it is to be ratified. All the expenses are supposed to be ratified by the stakeholders consultation committee as per regulation 31 capital A of the liquidation process regulations.
I don't think there is a requirement for approval.
There is a requirement for approval of liquidation cost. There is a requirement.
Okay. And
Yes.
the other question with regard to the appointment of IRP, the IBC law clearly states that the appointment, replacement, removal is with COC. In one of the cases, uh, I made an application with NCLT to allow me to hold COC because there was a stalemate between unsecured creditors and secured creditors. So instead of allowing me to hold COC meeting, the NCLT exercised its own power and appointed a IP from his panel.
Now, see, the NCLT might have felt that it is the duty of the IRP to continue as deemed RP. It is the duty of the IRP to hold the meetings for the appointment of RP. If the meetings are held and in the voting nothing has actually been resolved, then there is no action can be taken against the IRP. But in case the IRP has not even placed the agenda before the COC meeting for appointment of RP, then it is a non-compliance.
No, sir. We have placed the agenda, but there was a moratorium stay by the NCLT that you continue to work as IRP, but you will not pass any resolution. So the resolution was placed. It could not be passed because of the
Then
stay. Because of the stay. At the end of the hearing, after a year, the NCLT decided that there is a stalemate between presumed there is a stalemate between unsecured creditor and secured creditor. So they did not allow me to hold COC meeting. We requested for COC meeting. Let COC decide.
no, then probably the NCLT tried to resolve this and appoint another person from their own panel. That is the only way the NCLT could think, and it has been held in many cases that the adjudicating authority has the power to appoint and they also have the power to replace. So
No,
that
sir.
would be challenged.
Sir, here the issue which was raised by the secured creditor that unsecured creditors are related, that issue was never dealt with. The NCLT did not resolve the issue. NCLT presumed, and we were requesting for COC meeting only. So
So
there
I
is
think we all today we can say that there are possibilities that some injustice can happen with anyone, and whenever we try to file an appeal, uh, when the insolvency professionals are adversely impacted, we have not seen the NCLAT will give us a relief.
yes, sir.
NCLAT will follow the NCLT if it is a matter of appointment or replacement of RP. NCLAT is not kind of using their power, whether it was lawful or it was unlawful.
Yes, that is what
That
happened,
is
sir.
that is happening. So we all are
Ah,
agreeing to this, that yes, we are only a service provider. We have nothing in this company. NCLT is trying to decide whether who will become RP in this case. I think we all have to accept this because we are only service provider. We have nothing in the company. We have nothing to lose other than our fee. So a professional has to think that he's a professional only. And it has been clarified by many times that we are only a service provider, and a service provider cannot enforce someone that you must take service from me. So
no,
that is the kind of process that I think NCLT and even IBBI thinks, that a service provider cannot force someone to take service from me. Whatever
yeah,
comes,
I,
whatever
I,
other,
I agree with you, sir. So we are only abiding by the law. We are only requesting for COC to decide. We are not
yes.
saying that we should be appointed. And you
I,
are right.
I fully understand, and there are other instances also where we have also suffered, but we will not call it as injustice because we feel that we are only service providers. So the only
Agreed, sir.
thing that we must say, that whatever expenditure we have incurred and our fee should be protected. That
That
that is what we must do.
that also, sir, took 3 years to get the fee and expenses reimbursed.
Yes, it is
And we did
very
not
clear.
get relief from NCLAT also.
It is
NCLAT
very
said,
clear. It is very clear that we should get our fee and expenses. However, the replacement is the power of the adjudicating authority.
yes, thank you, sir.
Yes, yes, please. So I think we still have a lot of things to do. I would advise every insolvency professional to read these guidelines prepared by IIPA so that our error rate reduces and the show cause notices are not issued against us. In case we are vigilant, that will be really good. So thank you very much. We could not complete it because of the very large kind of document, and we can say even many common mistakes that we all are making. Therefore, the IPA has done the error, including me. Everyone should be very, very careful.
So thank you, everyone. I think we will uh, wind up, and it was a good discussion today. Thank you.
Thanks a lot. Thanks
Thank
a
you.
lot, sir.
Thank you.